So if we can go to the Mr. Justice J's judgment, which is at tab 23. I'll take this quite lightly, as the court has already read this judgment. We see at paragraphs 41 and 42 of the judgment, which are at page 127 and 128, that Mr. Justice J notes that if the closure notices were effective or section 114 rectified them, there would be a debt. But if they were ineffective or not rectified, then there was no relevant indebtedness under section 59B. At paragraphs 53 and 54, which are started on page 130, he concludes that the closure notice did not make an amendment to the self-assessment. And then at 71 and 72, that there was not even a purported amendment by reference to the language "I am amending." At paragraph 70, he held that the closure notices did not accord with HMRC's own guidance. And then at 74, which is on 135, 78, 136, and 83, 137, he held that the closure notices were defective and that section 114 could not apply to correct the position, where there was no amendment at all, because it was an existential issue. At 86, he says, which is on 137, he says that the closure notices had a gaping hole and were not compliant with section 28A. As my Lady Justice Simler noted, the 114 position is all a bit muddled, but he is absolutely clear that in relation to the closure notice, they were not rectified, cured by section 114, because the missing element of the amendment was too significant. That was consistent with the judgment of the Court of Appeal in Bayliss and Gregory. He rejected the judicial review application on the basis that Mr. Archer had a right of appeal to the FTT, so he said. Even this is curious, because at paragraph 69 of the judgment, which is on page 134, he said that an amendment to a self-assessment has specific consequences, not dependent on the finding of any further action by the taxpayer, save the ability to appeal the amendment, an amendment which he determined had not actually been made. In connection with the appeal, he considered that the curative power of section 114 would have applied, because now the tribunal appeal is an other proceeding. He doesn't actually address what was actually the likely cause of a first-tier tribunal not succeeding, which was section 70, subsection 7, because the first-tier tribunal has an obligation, if it finds that there's been an under-assessment, to make one. We had a self-assessment, and the tribunal could, or should, have, but 114 is a very odd way of getting to the answer.
I think you were corrected on the section number there for your junior, 50.
What did I say?
70.
Oh, sorry. I apologise. In my head, I'd said the right words.
It happens all the time. So that's the appeal against his interest point.
That's the appeal against his interest point.
So the point being that the FTT could have substituted effective zero because there was no amendment to the return with
they could have
the full amount of time.
What was otherwise unfixable. So HMRC couldn't fix
But
what
the FTT could have.
but the FTT could fix it. So assuming 114, we're in a 114 doesn't apply to the closure notice world. If the FTT had confirmed that 114 didn't cure, they could have said, well, that's all irrelevant because pursuant to section 50, subsection 7, they could have just made the assessment that HMRC had forgotten to make.
And the FTT was therefore not required to, they didn't have to go through the hoop of section 114 in order to do that, is what you're saying. They could just start afresh.
Yes. Mr. Justice J also hypothesised that if the closure notices were defective, then HMRC could issue new closure notices.
They could have done if the point had been drawn to their attention within the 30 days, but not once the 30 days expired. Is that right?
I'm not sure they could do it at all, because if the closure notices had closed, you can't open a closed inquiry. So
you can't substitute a new closure notice within the time and say that we've made a mistake. That one,
no.
Is it? Okay.
But Mr. Justice J, he didn't take that view. He thought that you could have further closure.
He thought they could issue another closure notice. Yeah. There wasn't any argument on it.
And that wasn't considered in the Court of Appeal, was it?
No. On the 114 dichotomy, if I call it that, as I've already mentioned, in the order, Mr. Justice Day recognised that there was a real prospect of success in relation to overturning his decision on 114 in other proceedings.
Yeah.
But he still refused permission.
Because he thought the claimant would lose either way.
Yes. So we've got this very peculiar position where there is determined to be no debt, but there's an abusive process. There had been, he thought that they could have issued another closure notice, but they hadn't. He thought that if there had been an appeal to the FTT could have, let's just say, done something. I say they could have done something that he hadn't considered. But there was no FTT judgment that had done any of those things. There was no substituted closure notice, and there was a defective closure notice that didn't create a debt. So, objectively assessed, what would a reasonable taxpayer have done? Handed the cash over?
Well, can you have it both ways? When you've got decisions going in your favour, it's reasonable for you to adopt those decisions and for us not to go behind them and look at what was actually in the taxpayer's mind. But when you've got decisions going against you and saying not only that you'll lose either way, but you should pay up now, you have the money, we can look behind behind that decision and say, well, it's reasonable for the taxpayer to think this is a very muddled decision, and why should I follow it? And I'll carry on challenging it.
Well, what we're saying is, objectively viewed by reference to all of the evidence and all of the circumstances, what objectively would reasonable taxpayers have done? And I didn't say it was just because there was no debt. I said that in all of the circumstances and the muddle associated with that judgment, what would an objectively reasonable taxpayer have done? So clearly we didn't actually win, but there were all of those pieces. And we know from Lord Henderson's order that he considered that there was no debt to pay, and that the effect of that ruling was to impute it from the 21st of February, either on the basis of the declaratory theory of judgment or pragmatically because there'd been no change. We see Lord Henderson's order at Lord Justice Henderson, sorry, at tab 30, page 157.
Yeah.
And he's clear that on giving permission, that there are important questions of principle about the contents of the closure notice that have real prospects of success. And then interim relief. The interim relief granted by the order should be reinstated and continue until determination of the appeal. I consider that it would be wrong in principle for HMRC to initiate or pursue bankruptcy proceedings against Mr. Archer at a time when, according to the judge, the closure notices were ineffective for failure to specify the amount of the tax due. That failure was incapable of remedy under section 114, and there was accordingly no statutory debt. So he recognised there's no statutory debt. Mr. Justice J had said that he should pay up, but on what basis do you pay up if there's no debt?
I'm not suggesting you should pay up. I'm just wondering when it is reasonable to rely on what the judge says and when it isn't reasonable to rely on what the judge said, and the extent to which the subjective views or the robustness of the advice comes into the picture.
So we do not rely on any advice, robust or otherwise.
I know.
So it is right that this court should take into account all of every judgment, because all of every judgment is a relevant circumstance. We say that to assert that a reasonable, responsible, conscientious taxpayer would have acted differently to Mr. Archer and made payment is to somewhat bravely contend that Lord Justice Henderson's order was unreasonable rather than reasonable.
So, I mean, your position really is then, whatever the position of Mr. Justice J and whatever he said, within a very short period, Lord Justice Henderson said what he said, and that resolves the position.
Yes.
Plainly.
Another way of putting it is that both judges, if you like, both judges are reasonable, but the taxpayer is entitled to rely, you might say, on
the one that was most clear.
Or the one that was most senior as well.
Yes. But most clear, I would definitely say, with all due respect to Court of Appeal Justices over High Court. By its judgment on the 30th of September, the Court of Appeal again confirmed that there was no amendment meeting the requirements of Section 28A. However, as we know, it determined that in the specific circumstances of Mr. Archer's case, he could have worked out how much tax was owed consequent upon the conclusions, and as such, the absence of an amendment to his self-assessment was a matter of form.
And that, I think, flows also from Mr. Justice J's judgment, doesn't it? He made findings about what Mr. Archer could have derived from it, but nonetheless said that it mattered, that it was not that there wasn't a calculation.
And this is the Bayliss and Gregory and Pipe point. I might hypothesise that in a different scenario, the Court of Appeal may well have found that the absence of an amendment was too extreme to fill, but not in the specific circumstances of this case, because Mr. Archer had been sent unconfirmed APNs. And so they stepped back and said, well, in substance, sorry, this has been a new substance twice, taken in the round, is this a matter of substance or is it a matter of form? In this situation, my view of the judgment is they concluded that it was a matter of, well, they did conclude it was a matter of form, but they did it because of the situation, not because in every situation the absence of an amendment would be remediable. But importantly, the court goes on to consider at paragraphs 42 to 44, which are at page 170. the question of jurisdiction and whether Mr. Archer was entitled to bring his case by way of judicial review. Although the preamble to paragraph 42 could indicate that what follows is obiter, logically it is a point which must have been considered as a necessary precursor to the determination of the principal debt question, because if there was no judicial review they couldn't determine the debt question. But I don't take a big point on whether it's obiter or not, because that's a rabbit hole that I don't think we particularly need to go down. But there is. In any event, the court's reasoning as set out in 42 to 44 is relevant and authoritative. The court determined that Mr. Archer could not be compelled to bring an appeal before the FTT entirely in his own interests, and that in any event, the jurisdiction to determine the existence of the debt was not one that fell to the FTT. As we've just discussed, the entirely against his own interest point is the section 50 subsection 7 point, which is also referenced at paragraph 6 of the Court of Appeal judgment. If Mr. Archer had appealed under section 31 1 against the conclusions, the tribunal could have remediated the problem, and that was to his own detriment. Paragraph 43 requires careful reading. The Court of Appeal describes the litigated question as a technical one, whether there had been an amendment to Mr. Archer's self-assessment, and as such, whether there was a debt capable of enforcement under the Insolvency Act. The only possibility of there being an enforceable debt under the Insolvency Act, that is to say an undisputed debt, in relation to the closure notices was section 59b(5). But that required there to be an amendment to the assessment. It's plain from paragraph 43 that the Court of Appeal considered that the question of whether the closure notices resulted in a debt or not was a matter for the jurisdiction of the Judicial Review Court or the Bankruptcy Court. Bankruptcy Court's referenced in 44. Of course, Mr. Archer was not going to bring bankruptcy proceedings because his whole judicial review was to avoid the jeopardy associated with bankruptcy proceedings or not be involved in bankruptcy proceedings. His actions in prosecuting the judicial review plainly had the approval of the Court of Appeal in these paragraphs. In these circumstances, Mr. Archer was not acting unreasonably in bringing his challenge by way of judicial review. Rather, it was the opposite. This court has expressly indicated that he was acting reasonably. The court didn't reference this, probably because it wasn't taken to it, but exactly the same position had been determined in Woolwich, and that's in Authorities tab 22.
Well, there's a difference between saying judicial review is the avenue to challenge validity and saying it's reasonable for the taxpayer to do so. I'm not sure anywhere does the Court of Appeal say that was reasonable. They found that this was a wholly technical challenge, and that as a matter of fact, the closure notices as rectified by section 114, which was always there and always available, made it absolutely clear to Mr. Archer, who knew full well what the tax due was. So this was a matter of form, not substance. I mean, they're not giving their blessing that he did the right thing to pursue judicial review proceedings. They're saying he couldn't, this was the avenue if he was going to take these technical points.
So, but that's the point I'm making, that it wasn't unreasonable to do so, not to do something else. If he wanted to test this issue, this was the forum in which he had to do it.
But they're not saying it was reasonable for him to test the issue. That's a different point.
That is a different point.
Okay. Sorry, I interrupted you. I'm so
Paragraph
sorry.
43 says that point. It says the jurisdiction point is in terms, isn't it? 'Cause in the fourth, fifth line, the court says it's not a question for the FTT. So the particular point that was taken on JR, they say in terms it's not for the FTT.
It's not for the FTT. as I was just saying, in Woolwich, tab 22, page 251 of the authorities bundle, starting 3 lines above F, with the word...
Sorry, would you mind giving the page number again?
Yeah, sorry, 251.
Thank you.
If I can ask the court to read from the word in at the end of 3 lines up from F down to return 4 lines down from G. The court there is saying that you challenge the lawfulness of demand by way of judicial review because to appeal it presupposes the lawfulness of the demand itself. So we have a situation in which leave had been given all the way up to this point, and we have a fluctuating position as to what the answer is. And it's that taken as a whole that we say supports the conclusion that the decision to bring a JR can't be impugned as unreasonable. The day after the Court of Appeal's judgment, on the 1st of December, HMRC wrote to Mr. Archer and invited him to pay within 14 days. I won't take you to it, but you'll note it's tab 33, page 174 of the supplementary. Accordingly, whatever occurred after that 14-day period came to an end, there must have been a reasonable excuse for not paying during that 14-day period. Whether or not it was an extension agreed under 1182 or not doesn't really matter. It must have been reasonable to have not paid within that 14 days. On the 6th of December, so comfortably within 14 days, HMRC agreed not to proceed to bankrupt Mr. Archer on the basis that he did not apply for expedition. The effect was to place the parties in the same position as if the Supreme Court had granted interim relief pending its determination of the permission application. And so, in effect, he was in exactly the same position as he had been on the 29th of March 2016. It's at least indicative that HMRC thought that the strength of the permission application was sufficient to justify interim relief. Otherwise, HMRC should have held their ground and gone with it. No further steps were taken post the submission of the parties' Mr. Archer's application and HMRC's objection until the 14th of June, when the Supreme Court communicated the decision it had taken on the 13th. Mr. Archer made payment 8 days later. Viewed objectively, do these facts establish a reasonable excuse for non-payment? Would a conscientious taxpayer, alive to his obligations, have commenced and continued the litigation without payment of the tax on the basis of the strength of the case, as determined by each level of court and then by reference to HMRC's at least implicit acceptance that further interim relief application would have been granted? It's contended plainly, yes. It's contended that it's a non-point that there were short periods for which there was no extant interim relief order. not only was Mr. Archer each time seeking permission to appeal and renew the interim relief order, but also the order in fact then granted, or simulated as granted by HMRC's agreement, confirms that that was the right course of action. Until the 13th of June, it cannot be said that Mr. Archer's case had been finally determined against him. By way of analogy, it's recognised in Section 2054 of Finance Act 2003 in connection with follower notices. 2014. Tab 12.
Which act? Which section? 205?
2054.
Sub 4.
Sub 4.
Yeah.
In the context of follower notices, that a judgment is not final until it's a ruling of the Supreme Court or a lower court that time limit has expired for or been refused. The fact that HMRC defended their position from the outset, contending that there had been an amendment and that there was thereby a debt, is just an inherent feature of the litigation itself. So Mr. Archer contends that he did have a strong prima facie case, justified by reference to the determinations of the court and HMRC's own position in relation to the collection proceedings. The second head is the no expectation argument. And this is predicated on circumstantial evidence that as no amount could or would be collected by HMRC for the time being, then payment of the sum during that time was reasonable and indeed expected even for a conscientious taxpayer alive to his obligations. In addition to the court orders and the agreement, throughout the relevant period up to 18th of June 2018, Mr. Archer's statement of account with HMRC showed that collection was suspended. And if the tribunal can look at page 262 of the supplemental bundle. This is a statement dated the 17th of June 2018. And as an example, we see the first example is a bit more complicated in terms of maths, but 31st of January 2002, first payment on account, there is a sum of 288,202,092, collection suspended.
There was some discussion about this in the FTT, wasn't there?
There was, yes. So the FTT rejected a conclusion that a reasonably conscientious taxpayer would have considered that suspension was collected.
Yeah, collection was suspended.
That no payment was required. But in doing so, the tribunal said, considering that a temporary pause on collection did not mean that the amounts did not continue to be due and payable, and absent evidence from Mr. Archer as to what he understood regarding collection, no reasonable excuse was made out. That's what the FTT said.
What paragraph was that?
134 to 139. But that's to answer the wrong question. The question is not whether the amounts were due and payable. That was determined with retrospective effect by the Court of Appeal. But whether in the circumstances it was reasonable to pay. We know that they were due and payable. The court's told us that. But before the court told us that, and while we were continuing our appeal, was it reasonable to expect payment in light of the collection suspended rubric in the statements?
But collection's the third stage, isn't it? It has got nothing to do with. Well, maybe that doesn't matter.
I'm struggling a bit with whether this is really an independent point of the court process, because the entries in the accounts are really surely a consequence of the interim relief being given and the continuation of it. Put it another way, if those changes hadn't been made to that online account, KPMG or any other advisor or Mr. Archer himself might have got on the phone to the revenue saying, hang on a minute, you say you're not supposed to be taking action over this. So to what extent does it really add?
Well, it's another fact and circumstance. What we do know is that if we go down to 263, we see against 10th of June 2016 first surcharge for 2001-2, and then we see collection suspended.
But that's of the surcharge itself.
It is of the surcharge itself. But the point I want to make is that when HMRC do not expect payment to be made for whatever reason, now here it's because they've suspended it in accordance with the postponement provisions, and we know that those postponement provisions have the consequence that penalties are not running. So it is an integrated point, but there is different material that support the position.
So you say, if I've understood it correctly, that this is the revenue signalling that this is like a postponement?
Yes.
Is that what you're saying?
And then in addition to that, we see that they also issued the screenshots for
Issued them, or they relied on them as part of the JR evidence?
So if I can take you to 273.
Yeah.
On the 18th of June, looking at the account, you have in bold letters, you have nothing to pay. One day later, at 274, we now have 24,770,613.68p to pay. We say this is just another...
But it's the point my lady made. It's just consequent on the fact that the revenue had agreed that they wouldn't pursue the bankruptcy proceedings until a decision from the Supreme Court on permission had been obtained. It's not an independent point. It's the same point, just reflected in different material, isn't it?
Yes. We say that they confirm that HMRC did not expect to collect the tax at that relevant time because of the interim relief orders or their agreement, but they did not expect to collect the tax.
But that doesn't mean, and there wasn't anything that said positively, that they wouldn't nonetheless visit the consequences of non-payment on Mr. Archer.
No.
And that's...
So the next and final point, and this is discrete, is the academic nugatory actionable cause point. The FTT rightly considered that the judicial review would have been rendered nugatory had the tax been paid, and that's at paragraph 116, core bundle tab 11, page 153.
Yeah.
The UT determined that it didn't need to decide the issue at paragraph 149, core bundle 7112. However, if making the payment would have rendered the judicial review proceedings academic or nugatory, and oblig, if there was a real risk that making payment would have resulted in a Pyrrhic victory, because the sums still paid could not have been recovered, we say it cannot be unreasonable to have not made payment until the end of the judicial review proceedings, the final end. It must be reasonable for a litigant to protect his position while he still has the prospect of success in his litigation. The form of the judicial review was a challenge to HMRC's decision to bankrupt. If he'd paid the sum in dispute, then bankruptcy would no longer have been in question. And with that threat removed, there would have been nothing for the court to review. The courts do not generally give their time to consideration of academic questions, still less in the context of judicial review, and still less again in the case of the Court of Appeal or the Supreme Court. Courts decide live disputes between parties, not hypothetical questions. HMRC reference L, M and P, which is at Authorities 30.
Yeah. It's Justice Elizabeth Lane.
And
No,
they,
it's the family one, isn't it?
Yeah. Isn't it Lady Justice Elizabeth Lane?
She is.
Might be.
She's a member of the court.
Sorry, which tab 30, LM and P.
LM and P.
Yes, right, she's in it.
She gave the judgment. Oh, I don't know. Maybe I'm wrong.
I
Yeah,
think
she
so.
gave the judgment.
Yes, you're right.
Sorry. Which paragraph did you want us to
So
look at?
HMRC refer in their skeleton to paragraphs 60 to 66.
60 to 66.
And on the basis of those paragraphs, they assert that had Mr. Archer paid his tax, his judicial review would not have been academic. They contend that the parties would have had an interest in resolving the debt question. However, the asserted interest of both parties in getting an answer on the debt question is not the test for whether it's academic. The question is whether there is a live issue in the sense of whether a remedy sought has already been achieved. LM and P were in relation to interim education healthcare plans. The claimants sought that the interim plans be quashed and invited the final plans be mandated. The final plans had all been issued before the proceedings were heard. Paragraph 60 to 66 set out a learned recitation of how to determine whether a claim is academic, and we have no dispute with it. On the basis that the EHCPs are refreshed and renewed on a regular basis, Lord Justice Peter Jackson indicated, to use my phrase, that the issues were dormant or latent. They may well have come alive again for the claimants themselves, and they were not, therefore, academic. But there's no indication in that passage that a mere interest of both parties in knowing the answer to a tricky question is enough to mean that there is a current live issue for the court to determine.
But is that what it would be? A mere interest in a tricky question? Wouldn't it be, I mean, leaving aside the bankruptcy and the debt point, this was a challenge to the closure notices, saying that they were defective. And there would have been the potential, wouldn't there, to run a judicial review asserting that these were null, invalid, void, having paid the money and expecting the money to be paid back if the taxpayer was proved right. And
Well,
in the meantime, that would be consistent with the APN background to this closure notice, which was all about people paying over the tax, not pursuant to a crystallised liability necessarily, but, well, the liability is crystallised by the APN litigation. But anyway, whatever.
So,
forget the APN reference.
I repeat, Mr. Archer did not have a crystallised APN liability.
He did.
I
There
appreciate-
was an APN, but they hadn't dealt with
hadn't
the
confirmed.
representations. That was the why it hadn't crystallised.
Yes. But the judicial review proceedings were against bankruptcy.
Yes, that's how they arose in that case.
And that was the relief sought.
Yeah.
And looking through the cases, it's about the relief that determines whether something is academic or not.
That's fair.
So, if he'd made payment, there could be no question that he could be made bankrupt because he'd made payment. So, the relief he sought was academic.
So if he'd sought a different type of relief, such as a declaration that the closure notices didn't amend the self-assessment, that could be a different.
And indeed, that's what happened in the PPN judicial review litigation. The taxpayers wanted stays. Some were granted them in the beginning, but in the end, most of them were not granted stays. They paid up the money, but they nevertheless challenged the validity of the PPNs. They argued that they were null and void, but they paid over the tax on the basis that the revenue would have had to pay it back with interest afterwards, had the revenue been wrong. That the same could have happened here.
With respect, no.
Why?
Because in this case, and I'm just about to steal Mr. McDonnell's thunder because I had allowed him to take the Pyrrhic question, but I'm now going to deal with it. There was a liability here.
Yeah.
Mr. Archer did not contest the closure notices. There was little or no chance of getting this money back if he was right that there was no demand. Because what basis would his action have had?
Well, it would be the same as the action that
No.
he... Why?
Sorry, with respect, my lady.
Well, just let me finish my point. He's saying that that the closure notice is defective and invalid. That's what they were saying in the PPN litigation. But a declaration to that effect would have been enough and would have required the revenue to pay it back.
Because there would have been no debt, essentially. There's nothing. I take your point on, like, you mean the underlying tax liability is
They
there.
can't collect it.
But, as we all know, there's more than one stage to obtaining the tax. There's the liability, then there's whatever assessment procedure. And Mr. Archer's point is that there wasn't an effective
You can't
assessment.
collect.
So he got the difference in the PPNs is that the liability at that point was not determined. It was still a payment on account of tax. The substantive liability was to be determined.
Yeah, that's
Yes.
right.
So, and we say that is a very significant difference.
Well, I'm not, yes, I think we might take some persuading.
Yeah.
Clearly there is a difference, but nevertheless you need a lawful collection mechanism. Just as in Woolwich, the revenue can't go round and, just demand money without the legal basis to do it procedurally as well as by reference to substantive liability. So I'm not sure how far that point takes you.
I'm going to give it another go as to why. In the PPN APN situation, you've got a collection mechanism that allows HMRC to hold tax that nobody knows whether it's due or not yet. If it is determined that that collection mechanism is invalid, it goes back to the status quo ante. It goes back to the taxpayer until it's determined that there's a tax liability. And once it's determined there's a tax liability, HMRC get the money again, because now you're looking at a different assessment process. So the first assessment process falls over and there's no liability. The second assessment kicks in because now you've got a liability.
Yeah.
The reason that you can get your money back in the first situation is because nobody knows whether you owe the tax or not. In our case, there was a liability to the tax. We were challenging the collection, the collection mechanism, the assessment, or lack of it. If we'd have paid it, it would have been money. We could never have said HMRC were unjustly enriched.
No, but you could have said it was an unlawful. I'm looking at Woolwich again.
Yes.
If the assessment is alleged to have been made under ultra vires regulations, the proper course is to take judicial review to quash the assessment and to say that it is not lawful. It's an unlawful assessment. And that is exactly the same here. You've got the Whitney 3 stages. This is the collection stage, and if the collection mechanism used is invalid and defective and unlawful, they can't collect through it.
But
How can they not then return the money?
in Woolwich, HMRC were not in. There was no liability, and an unlawful, and therefore an unlawful.
Yes,
Well, that may
there-
make it
there
stronger.
are lots of situations where that, taken out of time discovery assessment. We all know the liability is there, but the revenue can't collect. And if they weren't entitled to make that discovery assessment, the substantive liability remains, but they've got to refund the tax if it's been paid.
But in that situation, you've got a statutory process that provides for the return of the money, because you've got section 55 and 56.
Yes, I probably shouldn't have used discovery assessments because that gets us into the FTT, but situations where you have to use, I do think there's a point about Woolwich here, and if you can't collect the tax, it doesn't matter what the tax code says. If you haven't got the lawful mechanism to collect it, then that's money that you shouldn't have received.
I mean, if the taxpayer said to the revenue, I'm paying this money over to you, I don't owe it because you have issued me with a defective, invalid, void closure notice, but I'm paying it in order to avoid any argument subsequently in relation to penalties, interest, surcharges, whatever, and I expect you to refund it if I am proved right at the end of the judicial review proceedings. How could the revenue properly refuse to refund the money, notwithstanding the liability is there?
Well, if there were a formal agreement to that effect,
I'm not suggesting it's a formal agreement. I'm suggesting it's the taxpayer saying, this is why I'm doing it.
and I'm saying that if there were a formal agreement,
Well, that's
it
a
would fall
different-
within Woolwich. But it's Mr. Archer's position that if you look forensically through the Woolwich categories, we do not fall into any section that would allow for recovery. Not
Okay.
obviously.
Okay.
I think, to be fair, I think you will also say, I imagine you would say, in a sense, it doesn't matter what the correct legal answer is to this conundrum. It's whether it was reasonable to be, in this context,
Yes.
concerned that you might not get the money back.
And this is a pure legal question. Did the legal risk exist?
Legal risk, yes.
And that's, did the legal risk exist? If the legal risk existed, and that is a pure question of law, then taking the legal risk, you then assess whether, in light of that legal risk, is it reasonable to have not taken the risk. If I could just go back to nugatory for a minute. And so in terms of the relief, we know that if he'd have made payment, there would have been no basis for relief. So strictly, therefore, it would have been nugatory. You then have paragraph 50 of LM&P, which applies the Salem test. Paragraph 50 at LM&P is 411.
Paragraph 50.
Yeah, it's
415.
Lady Justice Elizabeth Lang's judgment, yeah?
Yeah, sorry, it's not at 411. It is at
415.
415. Here, the court assesses where there's no relief to give, whether the court will exercise its discretion. And a rigorous filter is advocated that there must be a good reason in the public interest in order for the court to consider a matter that is for which relief has already been given. We see that approach being applied in King against the Secretary of State for the Home Department, ABCD, which is at tab 34. That is the exercise of judicial review function in the Upper Tribunal of the Immigration Appeal. And at paragraph 38 of that judgment, which I hope is on 535.
534 it starts.
So it applies the filter on at paragraph 38 and then at 43 to 46 on the basis that the Secretary of State for Home Department had agreed to consider the family reunion application outside the immigration rules, there was no relief to grant.
Yeah.
In the matter of TT, which is at tab 35, the High Court was called to consider whether an individual had been an eligible child for the purposes of the Children Act, despite the council having agreed to treat her as such. The court heard the claim considering that it was in the public interest to do so because there were 75 other children for whom the council had not agreed a similar treatment. In each of these cases, the reason that the claims became academic was because the public authority itself has acceded to or already granted the relief. The court then had to decide whether, despite that, there was this wider public issue. But that would not have been the case here. If Mr. Archer had made payment, he would have been the one who gave rise to there being no need for relief. The JR claim sought relief from bankruptcy, and if there was no tax debt, there would have been no interest debt, and because the interest is parasitic on the tax. So if he'd have paid, he would have rendered his own case not needing of relief. A claim being rendered academic in this way is more reflective of what happened in Wynne, which is referred to in LM&P at paragraph 70. Which starts at 418. There's something very odd. 418 at the top bundle, but 416B.
Yeah.
That's why. PDF 418, page 416B. Mr. Wynne was a prisoner. He was required, he wanted to bring a judicial review claim and he wanted to attend court. He could do so if he got permission to do so from the Governor or Secretary of State. But he had to fill out a form and provide an undertaking. Mr. Wynne decided that he didn't like the form, he ripped it up and didn't fill it in. And the court dismissed his application because he had rendered any possibility of relief completely redundant. So Mr. Archer was in a Mr. Wynne situation, academic, and he'd made it academic, not the public authorities. There's also the question of whether there would have been a wider interest altogether. We already know that HMRC's guidance requires them to put an amendment in. Ms. Views had never seen one, and HMRC admitted that they didn't do that. Mr. Justice J had said that it was in their invariable practice. So what was the wider public interest in the determination of whether there was a debt absent an assessment when Mr. Archer himself had said, I'll let you off the relief, I'll just pay you. So there was no general wider interest. It would have been academic, and there's no general wider public interest. So therefore, the proceedings were nugatory. I'm just going to ask Mr. McDonnell if there's anything that he would like to say on
I'm grateful. On the Pyrrhic victory point, if it pleases you, my lady, there's 3 points. That the two differences between this case and Woolwich are that in Woolwich, the taxpayer was faced with an apparently lawful demand. The only reason for which there would have been no demand would have been if the statutory instrument was ultra vires, which plainly ultimately proved to be the case. We can see on page 186 of the authorities bundle the protest that was actually made. So this is in the judgment of Lord Justice Gibson in the Court of Appeal, which Lord Gough, giving the leading speech to the House of Lords, sets out the facts. And we see from letter E to the end of the page, description of the return form CT61Z being sent, and then at letter G, Woolwich returned the form, made payment, and wrote a letter saying, you should be aware we're presently seeking leave to commence legal proceedings. This payment is made without prejudice to any right to recover any payments, etc. But having written that letter, Woolwich plainly still had to go through the proceedings that we all know, and up to the House level to in fact obtain payment. And the reason that the House of Lords, the majority in the House of Lords, gave for effectively creating a new law that if you were faced with a demand which you paid, there was a right of recovery, was in my submission twofold. So firstly, the demand is apparently lawful, and so you face the threat of severe consequences, let's say, if you don't pay it, stigma, etc., as described in Lord Gough's speech. But secondly, that if you're right, if Woolwich was right that the regulations were ultra vires, there was no substantive liability as well as the demand being unlawful. And so plainly justice cried out for there to be a remedy beyond merely voluntary repayment by HMRC, which is what HMRC said the only remedy was the only remedy available. And you can see that at the outset of Lord Gough's speech. So you've got two features. You've got an apparently lawful demand with threat of compulsion and no substantive liability. Our submission is that this is the opposite. On a counterfactual, where Mr. Archer has succeeded in establishing that there's a gaping hole and Section 114 can't cure it. So in that situation, he would have established that there is no demand. He would be there is a substantive liability on the 3 Whitney stages, but there's no assessment.
Yeah.
He would have established that, and yet he would be saying, I want to rely on my Woolwich remedy. And the risk is that the logical process that the court would follow when faced with that would be to say, well, your point that there is no assessment is a very technical point. We're going to take a technical point against you. Because there is no assessment, you haven't paid pursuant to a demand. You have paid voluntarily, and so we're not going to grant you a Woolwich remedy. It's a sort of sauce for the goose, sauce for the gander approach. Now, we're not, I think, asking this court to decide whether that was right or not, but simply to see that there was on a legal analysis, a risk of that. And plainly, there would have been, in principle, other possibilities, such as an order of the administrative court saying, for example, instead of granting interim relief, saying, well, Mr. Archer should pay now, but HMRC must repay it if we ultimately conclude that there's no assessment. But that isn't what happened, and HMRC never applied for such an order. And one can speculate whether they could have done or not, but that isn't the facts and circumstances of this case.
Thank you, that's very helpful.
So that is the third plank of Mr. Archer's reasonable excuse. So moving very swiftly on, because I'm nearly going to be in under an hour.
We have asked you a lot of questions.
Moving on to the question of unreasonable delay. On the basis that a reasonable excuse exists until the 19th of June, or even the 14th of June, 19th of June is the day that HMRC lift the collection is suspended, 14th of June is the day that the court, Supreme Court's judgment is communicated. There can't be a serious contention that payment made on the 22nd of June was made without unreasonable delay. If the reasonable excuse ceased on some date earlier than June 2018, then the question arises whether the delay until June 2018 was reasonable. Both the FTT and the UT considered that the test for reasonable excuse and unreasonable delay were basically the same. On that basis, on the basis that they didn't consider there was a reasonable excuse, there was therefore also not an unreasonable delay. For the reasons that I've already stated, it's submitted that by reference to the evidence, there is a reasonable excuse for the whole period, including the gaps which the tribunals both identified. But we say that the point is actually more significant than that. The legislation must contemplate that the reasonableness of a delay is not the same as a reasonable excuse. Otherwise, there'd be no purpose in section 1182. The reasonable excuse would simply continue. A reasonable delay must at least contemplate a time for a taxpayer to sort out his affairs and put in place the money to make a payment or similar. Plainly, objective reasons for the length of the delay must be factors in considering its reasonableness. In the present case, the delay, if we take the 30th of November 2017 as the critical point, was a period of just over 6 months. That period included a few days from the Court of Appeal judgment to putting in a non-expedited application for permission. As such, it's not an unreasonable delay despite the Court of Appeal judgment. If it is accepted that a litigant is reasonably entitled to seek permission to appeal, the associated weight for the court's response must also be reasonable. There are two reasons. First, a party having embarked on litigation with a reasonably arguable case, in this case a strongly arguable one or one with real prospects of success, it's entitled to the finality of the litigation. Second, the length of the delay was entirely outside the party's control. Mr. Archer had placed himself once again in the hands of the court. The length of time required for the court to determine the permission question should be seen as, by definition, reasonable. It can be borne in mind as well that it is not normally a very long period of time. This one was quite long. HMRC have at times in this litigation gone further and somehow said that his application was hopeless. But their own solicitor thought that it was reasonable, otherwise, for the reasons I've said, he wouldn't have agreed to the interim relief. The permission application is also in the bundle, and this court can assess for itself its reasonableness or otherwise. The core argument was that Section 114 could not be used to cure the defects in the closure notices in this case, because they were correcting something that was radical in the document. In Bayliss and Gregory, the Court of Appeal had previously held that Section 114 could not be used to rectify an error which was an integral fundamental part of the assessment itself. And that's taken from SB 36202, paragraph 9. The Court of Appeal had failed to follow its own previous decision, and the closure notices were missing a fundamental concept. That it was an objectively reasonable application for permission to appeal is therefore apparent. While I wouldn't venture to say that the argument was correct, because the Supreme Court told me that it wasn't, it was an application with a coherent foundation. So we say that until the Supreme Court's decision in June 2018, it was a reasonable approach for a litigant to take and not an unreasonable delay. The period was extended by Mr. Archer's agreement to HMRC's request that he not expedite. So finally, ground 3, which I will take very quickly. The point, insofar as it arises, is primarily addressed in the appellant and skeleton argument. In short, however, the UT incorrectly determined that the question of postponement would not have arisen on any putative appeal to the FTT. The analysis assumes that an appeal was possible, albeit not in Mr. Archer's interest. For the reasons I've given, it wasn't even possible. But let's assume that the FTT was right on that. Where an appeal lies to the FTT, the tax in dispute is payable unless it is postponed. Section 55, subsection 2, provides that the tax on the amendment or an assessment or an amount charged as a result of a conclusion stated in a closure notice is payable on the basis that there is no appeal. Though it's unclear on what basis tax is payable in circumstances in which it's charged as a result of a conclusion on a closure notice that isn't an amendment. Section 55.3 applies to the postponement of tax overcharged on an amendment or assessment, and Section 55.6 provides that tax which is not postponed is due and payable from the date on which the postponement application is determined. So if you've got a bit that's postponed and a bit that's not. Thus, even if the debt question was one that the FTT had jurisdiction to consider, it would not have been open to defer a decision on postponement. Had there been an appeal without the question of postponement being immediately determined, HMRC would have looked to pursue bankruptcy against the bit that hadn't been postponed. So it's either there or it's not. It's either postponed or it's payable. So, and it's to be remembered that HMRC objected to the application of permission to the Supreme Court on the basis that it represented an abuse of process, because the JR themselves were an attempt to sidestep a requirement to pay. For the reasons that I articulated below, sections 219 to 223, forensically analysed, do not give rise to a prohibition on postponement.
This is in the context of an APN.
This is in the context of an APN. So our cases, we were not in an APN non-postponement situation.
Because they hadn't answered the representations.
Because they hadn't answered the representations. And the analysis set out in paragraphs 84 to 94 of the UT was never addressed by the UT. HMRC said that they didn't need to, and currently in HMRC's skeleton argument, it's not clear whether they do or do not accept. It's implicit that they accept that analysis that was put to the UT.
Sorry,
If
the
that's
UT
not
didn't
correct,
agree.
I'm sure Mr. Ghosh will correct.
The UT didn't agree with you on that, though. They thought that postponement was not possible.
Yeah.
No, they said that the question of postponement didn't arise.
No, but the analysis they go through indicates that because there was an APN process ongoing, that was enough to shut off postponement. That's what
That was
they
my
conclude.
reading.
But I'm not sure how much time we should be taking.
I'm
on
not
this,
sure
really.
how much time we should be taking on it.
Okay,
We'll read that.
very well. My reading, certainly, my lady...
You say they didn't decide it.
...is that she didn't decide it. They said that the issue of postponement didn't arise. If...
Okay, let me just give you the paragraph number so you can understand. It's 90. It's the discussion at 98, primarily paragraph 98.
Do you want me to deal with that?
Well, I think let's see whether you need to address that on the file.
If the analysis is correct, that there was no prohibit to postponement, then the Supreme Court objection was incorrect. HMRC stated that it could not be postponed because there had been an APN. I don't criticise them for that. There was no ability for us to reply to their objection, but who knows if I am correct that there was an ability to postpone, who knows what the Supreme Court might have done. So, with all due respect to my Lady Justice Whipple, I don't think you can say it's completely irrelevant to this point, because it might have a relevance. It's just it's a bit of a bitty. And unless I can assist the court further, those are my submissions.
That's been very helpful. Thank you very much, Ms. Brown. Yes, Mr. Ghosh.
May it please the court, I'm very grateful. Please may I ask, is the court sitting until 4 o'clock or 4:30?
Somewhere between 4:15 and 4:30 at a convenient moment.
Yes, of course. Please, may I do this? 1, deliver my submissions on the law. 2, once I've done that, identify the particular reasonable excuses that Mr. Archer is advancing, and then pick up my submissions on the facts, and then make my submissions good by showing you the material, if that pleases the court. My submissions on the law. 1. The default position is this, where there is an amendment, and here, in this case, what we've got is a Section 28A amendment that had to be cured by Section 114.
Yeah.
So we've got one of those. Just a trailer point, the revenue respectfully does not agree with a point raised by my Lady Justice Whipple. Lord Justice Lewison, in the Court of Appeal JR decision, in my respectful submission, is not saying that the construction and application of Section 114 not just isn't, but can't be a matter for the First-tier Tax Tribunal. He's not saying that at all in my respectful submission. rather what he's saying, and I will make this good, is these are bankruptcy proceedings. They're collateral proceedings. And of course the FTT has no jurisdiction in those. And that's all he's saying. So in the context of bankruptcy proceedings, the FTT has got no jurisdiction. And in assessing whether there is or is not a debt in these collateral proceedings, in these enforcement proceedings, the FTT's got no jurisdiction at all. That's it. That's all he's saying. And it would be very curious if the FTT did not have jurisdiction to construe and apply Section 114 as part of the tax code. Now, when you've got an amendment, including one, which is cured by Section 114, if there's no appeal, and these closure notices were not appealed, tax is payable. That's Section 59B, little 5. If there is an appeal, the default position is that the taxpayer must pay the tax subject to postponement. And they make this application first to the revenue, and if the revenue says no, then to the tribunal. And they have to have grounds for believing that the tax isn't due. The court has seen that.
Yes, and we were told that the default position is that if you've got grounds for appeal, then you'll have grounds for believing. And therefore, postponement follows as night follows day in that sense.
It's having an arguable case.
Yeah.
I think that's perfectly fair.
Yeah, okay.
So subject to, so you pay the tax, that's your Section 55G, subject to postponement. And just while I'm here, respectfully, my Lady Justice Falk was right. What the Upper Tribunal said was, look, when you've got an APN, even one that hasn't been determined, what the postponement provisions say is that if the relevant closure notice, the tax specified there, relates to APN tax, that's all the pressures on the word relates, then no postponement.
And here the bulk of the tax did relate to APN tax.
Yes, there's no doubt about that.
Yeah, and was I right in referring to paragraph 98? I think
It's 92 to 94 and 98 as well.
Okay, 92 to 94, thank you.
And the point being, this is really not going to take very long, this point. The point being that that's true whether the APN has been determined or not.
Yes. I think, to be fair, there may be an argument about whether on a purposive construction an alternative analysis is possible. And one of the concerns I have is that we shouldn't be necessarily determining that sort of point that's not directly relevant.
That, in my respectful submissions, for another day.
Yes.
I respectfully.
Absolutely.
3, this default position of you're arguing with the revenue, you've got to pay the tax, subject to postponement, bracket, not for APNs, close bracket. It's also subject to a revenue discretion. This relates to the surcharge, to mitigate the surcharge or not collect it at all. That's in Section 59C11. So that's a separate point to do with surcharge, but it's there, and I'll show you it. And if there is an appeal, that appeal is subject to, and again the court's seen this and the court knows it, the Section 50 jurisdiction of the tribunal. And that goes hand in hand with all of the provisions that relate to appeal. Yes, you should pay unless your tax is postponed, but if you do appeal, you are subject to the Section 50 little 7 jurisdiction. That's true. That's what Parliament's provided for in an appeal. That's what an appeal is. So that's the default position. That's point 1. Point 2, the onus is on the revenue, of course it is, to show that the conditions for imposing a surcharge, they've been satisfied. Well, the tax hasn't been paid, so we've done that. But 3, and this taps into the conversation all three of your ladyships were having with Mrs. Brown this morning, the onus is on the taxpayer to show that they've got a reasonable excuse, that they've got one of those. So it's not for the revenue to show that you haven't got a reasonable excuse. The taxpayer has to show that they've got a reasonable excuse for not paying the tax. 4. This reasonable excuse, it needs to exist for the whole of the period of default. It's throughout the period. So that's from 4th March 2016 to the day before he paid the tax, 21st June 2018. And this is an actual excuse in the hands of an actual taxpayer, which was a reason that the taxpayer didn't pay the tax, and it was an objectively reasonable reason. It was a good reason, but it's an actual excuse in the hands of an actual taxpayer. It's not a test of whether you've got a set of events that would make it reasonable for a hypothetical taxpayer. That's not the test. And you get that from the text of section 59C, little 9, talks about an excuse for the taxpayer. The court has this point, it's obviously so. So for instance, an illness or computer failure for a sole trader is a completely different circumstance to an illness of a tax manager or computer failure of a major PLC, and so on.
You're referring there to reasonable excuse as used in section 15.9.
Yes, Maddie. So the exercise of identifying whether a particular taxpayer in a particular case has got a reasonable excuse, this is the parent exercise. 1, find the facts, and this is a function of evidence, not analysis, as to what this excuse throughout the period was. And just in parentheses, I'll pick up a point. We have these 2 periods. One is from the first time the taxpayer, Mr. Archer, lost in the administrative court. So on the 21st of February. And that period between then and the 7th of March. And the way that my learned friend put it was, the declaratory theory of law means that you impute what my Lord Justice Henderson said, that, of course, Mr. Archer does have a reasonable grounds for JR in these amendments. We don't accept that. You could say exactly the same about what the Supreme Court said on the 13th of June. So that doesn't work. It's not a wait-and-see exercise. One assesses whether there's a reasonable excuse to not pay the tax as at 4th March 2016, right through to 21st June 2018. So you find out...
when you say, are you saying you assess it effectively for each day in the period, not after the event? Can you just explain that a bit?
Yes, of course. We've got this period of default from 4th March, where the reasonable excuse has to exist, right through to the day before actual payment.
Yes.
So it's that the pressure's on the word throughout. So it absolutely does have to be assessed on a day-by-day basis.
Okay. Looking at the circumstances on that day, say, for example, the day after losing in the admin court, you haven't got the benefit of what Lord Justice Henderson is going to say.
What you are doing for that 2-week period is exercising rights of appeal, and for permission to the Court of Appeal. And then the same is true from the 30th of November 2017. You haven't got the benefit of any court telling you that you've got good grounds for JR. You're exercising rights of appeal. That's, in my respectful submission, a different reasonable excuse. to find out what the relevant component parts as a function of evidence, what these are for the excuse. And then 2, because it has to be an excuse, that's the point about this set of events has to be causative. They have to cause the non-payment of tax, otherwise it's not an excuse. And it's then and only then that if you've got a set of events which comprise the taxpayer's reasons for not paying, they did cause the non-payment, that's the time at which you assess whether it was reasonable to not pay. And yes, you take account of everything. Well, that includes, just to trail what I'm going to show the court, and there's quite a lot you can say about my Lord Mr. Justice Jay's judgment in the administrative court, but he gave a very clear instruction on the face of the judgment to Mr. Archer to pay.
That's in the order, isn't it?
It's at paragraph 106 of the judgment, my lady,
Okay.
as well as the order. It's on the face of the judgment. I'll show you, but please, the court should take it from me, it's on the face of the judgment, it's not just the order. I mean, it's there too. Two, you take account of the statutory regime. That informs what is or isn't reasonable. And here we have a regime that says if you've done a scheme which is subject to an APN, determined or not determined, that doesn't matter. But you've got one of those. You've got a scheme subject to an APN. Parliament has said, well, those schemes which fall within the categories of what is within an APN, we don't want those. So pay now and argue later. That's the default position. And
Why didn't HMRC get back on the representations on the APN?
I don't know. I can say this in open court. I have asked and no one knows.
Because that, as I think about it now, that would have short-circuited all of this, wouldn't it?
Yes.
I mean, it would have gone.
Yes, I have nothing I can help this court with about why the revenue did not.
But I think you do make a point that they could have completed that process at any time.
I make that point because that's a function of principle, that the revenue at any time could have determined the APNs, that's true. But as to why they didn't, as I've said, I can say this in open court, I've asked those instructing me, they don't know. But please, if I may pick up this point about the statutory regime, you've done a scheme. You've been given a follower notice, that's a section 205 point. You've been given an APN. You know what the tax is. And the default position, if you don't appeal, is that you pay that tax. What tax? The tax that's the subject matter of the conclusions in the closure notices as, it turns out, cured by section 114. That tax. And then you assess when that, even if you've got a reasonable excuse, you assess when if and when it ceases. And as I've said, for that 2-week period between 21st February and 7th March, what Mr. Archer was doing was exercising rights of appeal. And the same is true between 30th November 2017 and the Supreme Court saying no arguable case on the 13th of June 2018.
I don't think actually it's a second appeal, isn't it? So it's not that it's no arguable case. I haven't seen the Supreme Court order, I don't think. The second appeal criteria are a bit lengthier than that. It's no point of public principle as well.
That's right, but the order actually says no arguable case. It's an order I've seen myself many times.
We all have.
We all have that misery inflicted.
So anyway, I've been there. So the answer to my lady's point is that the Supreme Court says in terms no arguable case. And yes, on second appeal.
On second appeal.
The criteria. I've lost my... Oh, that's right. Now, in asking that, even if you've got a reason, even if you've got an excuse and it caused the non-payment of tax, is it reasonable? What we know And here, the revenue do quarrel with the analysis in, I'm going to call it Sheeling just because that's what's in my head, Sheeling, about this distinction between substantive invalidity and procedural invalidity. Because what the Upper Tribunal says in Sheeling is, if you're arguing about the application of the tax code, if that's what you're doing, that's never a reasonable excuse. And of course that must be right, because you have that fight in the First-tier Tribunal, no matter how strong your case is, no matter how robust your advice is. If you're arguing that a particular tax provision means X and not Y, and the revenue say no, it means Y, that fight is done in the First-tier Tribunal, and you pay your tax subject to postponement unless it's an APN, in which case you pay your tax. That's what you do. Unless you've got a reasonable excuse. And it's true, sometimes you don't need to lead evidence about belief, something like illness. But you do have to show causation. You do have to show that.
Sorry, I don't think I've fully understood your point about Sheeling. You were quarrelling with the distinction between substantive and procedural. You address substantive.
I'm about to go on to procedure.
Okay, thank you.
Now, procedure. Now, first of all, the Upper Tribunal in Sheeling calls a fight about substance one of substantive invalidity. I think that's perhaps a misnomer. If I'm fighting the revenue, one of us is right and one of us is wrong. It doesn't make the amendment invalid. It's just wrong. I appeal against it, and the FTT says that's wrong. There's nothing invalid about it.
I think they were thinking of things like the conditions aren't met, weren't they?
Well, no, that, or at least...
Or is that a procedural invalidity?
I think they would say that's procedural.
Right.
Because what they say is, if your fight is about whether you owe this tax at all,
Yeah.
because you're saying the tax code behaves one way and the revenue saying no, it behaves another way, that's never a reasonable excuse, because you've got to have your fight. And Parliament said if you're going to do that, pay your tax subject to postpone, all that. If, however, exactly as my Lady Justice Simler just said, it's a different fight. And you could have this fight about discovery assessments. You could have this fight, as we're having here, about this amendment that had to look to Section 114 to be cured. You say, well, the taxpayer here is saying this assessment mechanism is bad. Now, and they say, the Upper Tribunal in Sheeling, that could be a reasonable excuse. And in my respectful submission, that is, it's not a helpful dichotomy for this reason. This case, and this case may be very helpful to actually focus and resolve and distill this issue. The fight is all to do with the scope and application of Section 114 in relation to particular closure notices issued under Section 28A. That is no less a tax dispute than whether the two schemes that Mr. Archer did that were subject to the APN worked or didn't work.
In other words, you can dress up a substantive dispute as a procedural invalidity argument. Is that what you're saying?
I'm saying, well, no.
Because the argument wasn't Section 114. Well, it became Section 114 doesn't apply, but it started out as there is no debt. The closure notice is defective. So
I'm not accusing Mr. Archer of, in this case, dressing up a substantive complaint, because that's to do with whether his schemes worked or not. They just don't work. As a procedural complaint, I am saying that the nature of this kind of this fight has got, it's no different in quality to a fight about whether a scheme works or not, about or about the substance of any
Well,
tax.
when you say inequality, both could be the subject of FTT decisions. But how much further than that does it go?
I'm saying both disputes, both types of disputes, involve the construction and application of tax provisions, which are well within the jurisdiction and expertise of the Specialist Tribunal, the FTT. Nothing more. The tax provisions in the tax code, and the right place to find out what they mean is the FTT. What is true is that what has been called a gross or obvious error, the decimal point being in the wrong place, somebody's been assessed for 100 million instead of 1 million, for instance. The question there is, given the default position where, unless the tax is postponed, if you haven't got an APN, you should be paying the tax. Is it reasonable to say I'm not paying 100 million? Answer, yes, because it's gross and obvious. It displaces the default position. But not because it's a procedural error. It's not because you've created a population, a subset of circumstances which are somehow privileged. It's simply, you look at what's happened and you ask, is this event one that has caused you not to pay the tax, and was it reasonable for you not to do that? Your self-assessment was amended to 100 million, and you say, well, I'm not paying that. I've got 100 million. I never earned 100 million. You've got the point. It's so gross, so obvious, or just gross and obvious, it displaces Section 55(2), subject to postponement.
Sorry, are you using gross or obvious in the sense there of not curable under Section 114? Not.
I'm saying that where you've got an amendment made to a self-assessment or any form of assessment, which has an attribute inherent in it, that, and my 100 million example is one of those, the taxpayer may well say, I'm not paying that tax or applying for postponement because this is simply wrong, and I can show it's wrong. And what really all I'm saying is calling it a procedural invalidity or a procedural error doesn't help. You simply identify what is it that has said to this taxpayer, I'm not paying that tax, and is it reasonable?
So an assessment that doesn't identify the tax that's payable would be just as gross and obvious.
It might be, unless it's pretty clear to the taxpayer as to which there could only be one tax and it's the right number. I don't want to paint myself into a corner, not because I'm running away from the issue. I'm simply saying that there's no need to identify a category of excuses as procedural to say they're privileged. You simply look at each event and ask, is that why I didn't pay the tax? Let's look at whether that was reasonable of you.
Okay, but it may in Tuning have been a fair way of trying to explain why the underlying point about the APN code, which in what they call the substantive invalidity case, that can't be a reasonable excuse. It may be a way of explaining that this could be something of a different quality.
Yes, and I think the point I'm making, I don't want to spend too long on it because, again, it's one of these points that I'm making here because it goes to the heart of Mr. Archer's submissions, that he says this is a gross and obvious procedural defect in the closure notices. To elevate that to a principle, to say as a matter of principle, we can identify a category of procedural errors, procedural invalidities, is unnecessary. That's all I'm saying.
Okay. Well, it's certainly not there on the face of the statute.
And it doesn't
At
need
least
to
say
be.
that.
And that's all I'm saying. It doesn't need to be. In the same way that neither is illness, but it might be a reasonable excuse. An error on the face of closure notice that needs to be cured may or may not be, and in my respectful submission, and here we're getting to it, the tribunals have had to grapple with, you were shown some of them, Chapman, for instance, exclusive promotions. They all start off with this dichotomy of substantive invalidity on the one hand, procedural invalidity on the other, and then they all use words like you have to have a robust basis, or it's exceptional. And really, what they're saying is, in this case, the complaint you've got does not amount to a reasonable excuse. And that's really all they're saying. And that's why they've had to do this, I say, unnecessary exercise of saying, yes, procedural invalidity, but it's not gross or obvious or exception. They can just get straight to the point to say, look, relying on that to not pay your tax is not reasonable in the light of the statutory regime. That's all they have to do. Then, please, may I identify and make submissions on the specific reasonable excuses that Mr. Archer relies on. One, he says he has an arguable JR claim. And I say each of these reasonable excuses has to satisfy one. I'm going to call it actuality, but he's got to show that that was an actual reason for him not paying the tax. Two, I mean, this bleeds into one, it was causative. It was the reason why he didn't pay the tax. And three, it's reasonable. Now, it's been put in different ways, but the first way it was put was this having an arguable JR claim is of itself a reasonable excuse. And I'm saying, well, no, it isn't. Why not? One, to elevate that to a principle cuts across the statutory provisions. It cuts across Section 55, subject to postponement. Bracket not for APNs, close bracket. And my Lady Justice Falk, put it in a way I respectfully agree. Whether or not the Upper Tribunal were right, the postponement wouldn't have been available here is a point for another day, because it's a knotty point. But on any view, you lose, point's been made, a right of postponement under Section 56 if you're a taxpayer and you've lost in the FTT. You just do. And yes, it's dependent on the revenue saying, give us the money, but you do, you lose it. So again, the proposition that by not appealing and running a JR is of itself a reasonable excuse for not paying the tax cuts across these provisions. Getting to the surcharge, it cuts across the revenue's discretion to mitigate or not collect the surcharge at all in 59C11. Again, to elevate the proposition that having an arguable case, whatever degree of confidence you've got in your case, to a principle that is automatically a reasonable excuse, that cuts across 59C little 9, where it says a reasonable excuse of the taxpayer. That means the particular taxpayer. in this case, this is all in circumstances where Mr. Archer knows the schemes don't work, he knows what the tax was, there's no dispute about the arithmetic. So there's no question of him being confused or misled. He's just not paid. What about causation? Well, this is a short point. There isn't evidence. We know he's taken a JR. We all know that. But the revenue, because he's not appealed the closure notice, and he didn't give evidence in the surcharge appeal, has had no opportunity to cross-examine Mr. Archer to find out if there were other reasons, and the onus is on him.
I couldn't see, I don't think we've got the statements of case in the papers, but I had a look in the First-tier Tribunal. From what I could see, there wasn't any issue at all on the facts about causation, partly because it looked like everybody had rather taken the view, including the taxpayer, that it was all about reasonable belief, but it didn't seem that anybody had said, hold on a minute, did you really not pay because of the JR? Was it not because of something else?
Well, that might be true, but the decision we're interrogating in this court's, of course, the Upper Tribunal, because they remade the decision.
Yeah.
I mean, I can't say very much.
You're still looking at the same. I mean, it quite often happens in this court that you end up going back to the FTT to see what the evidence was or what arguments were at that stage.
And it happens that one party or another thinks, oh, if only we'd done this or that, well, that happens. The revenue are still being haunted by Burgess and Brimheath because, that happened. For those of you who don't know, the revenue raised discovery assessment but didn't need any evidence, and then the Upper Tribunal said, well, where's your evidence? And they said, well, we haven't got any, so discovery assessment failed. And the fact that it hadn't been debated below didn't save them. That was the point. Because the onus was on the revenue. It's not a bad analogy to this case.
Yeah.
Having a JR, even an arguable JR, of itself, even laying aside absence of evidence as to whether that was Mr. Archer's true reason, underlying reason, whatever word you pick, did it cause the payment of non-tax? We haven't got evidence about that. Now, just about this, there are three ways to establish causation. This emerged after an exchange between Mrs. Brown and my Lady Justice Whipple. One, causation can somehow operate as a matter of law. I simply don't understand that. It's not a figure of speech. I don't know what that means. That you can have causation operating as a matter of law unless there's a deeming. There's no deeming here. Or, as a function of evidence, it's so obvious that it's self-evident and the tribunal's entitled to make a finding. Or you can make an inference. None of that's happened in this case.
When you say none has happened, you mean what? You mean in the course of remaking the decision,
There are no findings.
there was no finding.
Or either by one operation of law, whatever that means, two, self-evident primary finding, or three, inference. It's the opposite. You saw, Mrs. Brown said, I'm not asking you to make inferences. Again, I'll show the court this.
Yes, the appellant would presumably wish to persuade us that the UT has made an error of law and then invite us to remake the decision.
And the Court of Appeal has clearly got jurisdiction power to do that, but on findings of fact, in circumstances in which Mr. Archer has given no evidence, where the onus is on him.
So that's where the blindingly obvious and inference, alternatives arguably come in.
Well, there might might come in, but the question is, what does the court do with that in circumstances in which the revenue has not had an opportunity to cross-examine? Is it self-evident? And it's not a rhetorical question. If you're going to make an inference, all that speculation about did Mr. Archer say, well, I'm not paying the revenue £22 million unless I have to. I'm getting a better rate of return elsewhere. We don't know.
But still, we'd have been. I mean, it's getting a bit fanciful, isn't it? Because still, we'd be looking. That's why I was looking at the FTT to see what they found as a fact. And nobody seems to have mentioned causation as an issue in the FTT. So we'd be none the wiser, Mr. Gosh. That's the point. If it was us making the decision now.
No, but in the FTT, the onus was on the taxpayer to lead the evidence they needed to lead to establish causation. That is not my problem.
You say that the absence of evidence is Mr. Archer's problem here.
It absolutely. They can't make it my problem. It's for
Well, also, but no, because what you said was we had no opportunity to cross-examine him to find out if there were other reasons. And so that's why I ask you that, because nobody was suggesting the points that were argued in the FTT were 100 miles away from this.
They might have been, but the taxpayer made no application to bring in further evidence to the Upper Tribunal, which they could have done. And they didn't invite inferences. This court, all appellate courts, this court in particular, will be faced with, as my Lady Justice Whipple says, many, many, many times, with cases that might have been decided differently if evidence had been led below. But you can't make that the revenues problem in a world in which the onus is on the taxpayer to make their case good.
Yeah, we have this argument does come up quite a lot. Just so you know.
And I remember doing a case called Tooth in the Court of Appeal before it, by some miracle, ended up in the Supreme Court, where what the Court of Appeal said was, well, the revenue could have made all sorts of submissions on Tooth, but they don't get another chance now. It's too late. I don't want to dwell on Tooth. I mean, you know, to have a warm feeling when I speak about it, but it's the point I'm making is a real one. In a world in which the onus is on the taxpayer to make good a reasonable excuse, defects in either raising an issue which is relevant or evidence which is relevant can't be made the revenues problem on appeal. So that's why I'm saying that having an article JR claim of itself, I've mentioned it several times now, that cuts across and is all the relevant statutory provisions. It is not, even if you get there, not reasonable, but as it happens you don't get there because there's no evidence to show causation, and indeed that it was the reason why he didn't play in the first place. The second way it's put is that, well, paying the money would have made the GR claim nugatory. Well, no, I don't accept that. Number one, the court's already had the conversation with my learned friend saying, well, these are bankruptcy proceedings. That's true. Bankruptcy proceedings, absolutely right. That's the archaeology. But if you paid your tax and it turned out you were right, 114 didn't cure these closure notices, you would have got your money back. Yes, in the context of bankruptcy proceedings, but so what? You would have got your money back. The revenue can't collect the tax.
Well, you say that, but is that right? Aren't we looking at whether it was reasonable for the taxpayer to think there was a risk that he might not have got his money back?
Well, that again, would need to show that, one, that risk was what was in Mr. Archer's head, two, that's what it caused him
Well, that's a
not
different
pay the
point.
tax. I know it is, but I'm just
Yeah.
dealing with that now.
Okay.
And then 3, it was reasonable. And my Lady Justice Simler's question is, well, if you could establish the first 2, was it reasonable? Answer, in my respectful submission, no. It is, in my respectful submission, fanciful to say that in a world in which I have paid tax because the revenue is, HMRC are demanding it, and it turns out to be ultra vires, I don't get my money back. That is woolage. It's not voluntary, this payment. The revenue are saying there's a statute here.
Well, there's certainly a demand in terms of a threat of bankruptcy proceeding.
But on the basis that section 114 cured the closure notices and created a debt. So they're saying that that's our statutory basis for taking you to the bankruptcy court in the first place. That basis turns out to be wrong. That's ultra vires. They can't have their money. They can't keep that money. As it happens, Mr. Archer could also have avoided the surcharge by paying the tax at stake, the 14 million, and not the interest. I said that. So I don't accept that these GR proceedings would have been nugatory. But just to deal with this point, I've dealt with it already, but just in case it's lost sight of, it was raised by my Lady Justice Falk. Well, forget about what the right answer is that would a reasonable taxpayer have been worried enough about the risk? That's a function of evidence as to whether it was in Mr. Archer's head, did it cause the non-payment of tax before he get to it?
Isn't it a blindingly obvious point? What is it? Did it require evidence? I mean, we've got a taxpayer who is faced with a closure notice that doesn't include a calculation of the tax, so it's defective on its face, subject to being cured by section 114, and an argument about the scope of 114, and courts serially giving permission to argue these points and granting interim relief, or the revenue accepting interim relief should be effectively granted. Isn't all of that enough to say that the taxpayer had an arguable case and acted on that arguable case and thought that there was enough of a risk if he paid that he might lose his case?
In my respectful submission, my lady, no. That's an inference. All of that's an inference and speculation. Number one.
You say that's it. That it's not blindingly obvious. It's inference and speculation.
Yes, and so far as not getting your money back, fanciful speculation. In my respectful submission. And so far as the may I respond to the reaction of my lady?
Sorry, I was going to
Justice
say
Whipple?
something and then thought I'd just let you carry on.
Well, let's just have the answer first.
So far as the whether or not what my Lady Justice Simler calls courts serially giving permission, the court's got the point. I'm saying, well, why does that mean you shouldn't be paying the tax? In a world where Parliament says you've got to fight with the revenue, you pay your tax, subject to postponement. And the closure notices haven't even been appealed against. So that's one. And then second, well, I'm very worried that now that I've embarked on this JR, if I pay the money to the revenue, they won't give me the money back. That's evidence. I am very worried that the revenue, there's no evidence as to what the revenue would or wouldn't have said. And as a matter of law, we really don't have to spend very long to know that an ultra vires demand is expressed in woolage. The court knows that.
Sorry, the court knows.
That in Lord Gough's judgment, he says in terms, an ultra vires demand by a public body for money.
Yes, I mean ultra vires, of course, that language was used in the context of ultra vires regulations,
Yeah.
But you say here any demand that's not pursuant to the proper statutory basis,
exactly.
You put in the same category.
And that must be right, my lady, because the revenue can't do anything without a statutory basis.
Yes, so I mean, in essence, you say they would have had no statutory basis to go off to threaten bankruptcy proceedings apart from anything else.
Well, and that was the very basis of the JR in this case. That's what Mr. Archer was saying. His other point was, well, I know my scheme didn't work, or my two schemes didn't work, so I wouldn't have got my money back. That's heavily ironic if you're asking if a taxpayer is being reasonable. You say, well, I know that I owe this money because my schemes don't work. I'm taking a JR because I don't believe Section 114 cures these closure notices. The statute provisions tell me that subject to postponement, I should pay if I had appealed them. Because I'm JRing, I'm not going to. Because I know my schemes don't work. It's just another way of saying you're relying on a technicality, and we know that. We know that. But if you're having a fight with the revenue, the parliamentary edifice structure says you pay your tax subject to postponement. And if you don't, there's a surcharge, which is what this case is about. Put another way, in Dun and Gray, Mrs. Justice Elizabeth Lang, what she actually says is, if you're going to take a GR, maybe it's a reasonable excuse. Maybe it is. It could be. You know, whatever it is, it might be. If you win, tax charge drops away and your penalty drops away. If you lose, you get both. That is a perfectly coherent statutory regime.
Well, another way of putting that is to clarify this is that the effect of Section 114 curing the closure notice is that the debt was there.
I was going to address that.
Yeah.
And
But I think it's part of the same point, really, isn't it?
it's part of the same point in this sense. Yes, the Court of Appeal, my Lord Justice Lewison's decision tells you the debt was always there. No, the question
was
about
just
that.
recognising it.
Yeah, well, the court had to find it,
yeah.
yes. The question is, until you got that decision from the Court of Appeal, was it reasonable to not pay your tax? That's what this case is about. And I'm saying, no, it's not. And I'm testing it by saying, imagine a taxpayer just in a normal statutory FTT appeal who thinks they've got a terrific case on the substance. Got a marvellous case. They've got to pay their tax subject to postponement.
But if they have got an arguable case, the default will be they don't have to pay their tax.
Unless it's an APN.
Yes, absent the APN.
Absent the APN, that's right. But they have to go through those hoops. They actually have to properly appeal and get their postponement if it's not an APN, and they can't if it is an APN. Otherwise, they're on the hook for a surcharge. What you can't do, in my respectful submission, which is what this case is about, is saying, well, I'm not appealing the closure notices. I'm going to take a JR on collateral proceedings, which is the bankruptcy, rely on collateral invalidity.
Well, it wasn't their choice. The bankruptcy proceedings were the revenue's choice. That it wasn't the taxpayer's choice to go down a collateral route. The revenue, for whatever reason, rather than correcting the closure notices, if that was within their power, perhaps it wasn't, went for bankruptcy proceedings.
I hesitantly, when I say hesitantly, because I don't want to make a model of this because it's not necessary for me in my case. You had the closure notices.
Yeah.
In February, 3rd of February, 2016. They were never appealed. The revenue said, give us the money.
Well, how could they appeal them? If they'd appealed them, it would have been an appeal against their interest.
can I come to that? Because in my respect for the mission, they could have appealed them, no question. And I have addressed you, I've trailed this point, that I think the FTT had jurisdiction over.
I know you say they had jurisdiction, but it would have been an appeal against Mr. Archer's interest, wouldn't it? Because it would have given rise to the Section 50 powers.
That's right. But, my lady, in any case where, and there are taxes where postponement can't be made, diverted profits tax, for instance, that's a tax that just exists. Can't be postponed, it's got to be paid. It's always going to be in the taxpayer's interest to say, I want a JR rather than.
But, Mr. Butcher, how realistic is that? The taxpayer was actually threatened by bankruptcy proceedings, with bankruptcy proceedings. Even if he filed his appeal with the FTT, it would, I mean, if the time that would take to get through the system what difference would it make? Would you say if he'd filed that appeal, then the bankruptcy proceedings would have stopped at that stage because that's the revenues approach? I'm just trying to understand
I suppose
how it deals with the practical problem that he was faced with.
it depends which problem we're on about. If in
Bankruptcy proceedings.
Yes.
so if it's simply he says, well, and he says this in his witness statement, I don't want to be made bankrupt, then he absolutely could have said, well, I'll appeal in the normal way, you don't have to threaten me with bankruptcy proceedings. I will appeal the closure notices, and we have to have this fight, the fight that has been mentioned, but put to one side about whether or not I can get postponement.
Yes.
And then if I get postponement, I'm good. If I don't, well, I don't get a surcharge. I have to pay the tax, but there's no surcharge. So that's one obvious route that it could have taken. I will appeal, and yes, in appealing, I'm walking into the Section 50 jurisdiction. That is true. But in my respectful response to that is, so what? That's what Parliament has said the FTT can do.
But sorry, the anterior question, and this may be addressed by what the revenue say is their practice. If he had appealed, would the revenue have not pursued the bankruptcy proceeding?
Can I take instructions? Because
yes, because I think that the practical problem he's faced with is a threat of bankruptcy proceedings. I think I saw somewhere in the papers, I can't remember where now, something that led me to think that if there had been an appeal to the FTT, the revenue would at least in practice have not pursued them. And obviously, if they had, there would have been an argument in the bankruptcy court anyway about a dispute.
well, what there might have been, which happens quite a lot in different contexts, is that there are parallel proceedings in the FTT and JR. Yeah. It happens all the time. Yeah. I think the court is well aware of such proceedings, and one of them stayed, and one of them goes ahead, and that could have happened here. But I will take instructions as to what the revenue would or wouldn't have done. But my submission here is, given that we're talking about a surcharge, Mr. Archer should have paid the tax. He didn't have a reasonable excuse by saying, well, because what his complaint was that the closure notices were bad and couldn't be cured by 114. That's his complaint. He had a substantive complaint, which is that he'd done 2 schemes which he thought worked, and that ship had sailed. They were held by the Court of Appeal not to work. Now he's got another fight, and he says, well, this fight's all to do with whether 114 does or doesn't cure the closure notices. That's another fight. And I say that even in the circumstances which did happen in response to my Lady Justice Falk, that he went off to bankruptcy, the revenue pressed, and he took this collateral invalidity point in the bankruptcy court. he should have paid the tax. And for the reasons I've given, it would not have made that JR nugatory. To avoid the surcharge.
Okay, but some of your submissions are effectively, seem to be saying he should have appealed to the FTT instead, whereas we've got Lord Justice Lewison saying absolutely not required to and was against his interests.
My submissions, in my respect, I say respectfully, are good whether or not he should have appealed to the FTT. The only question here is, he went off on JR route, should he have nevertheless paid the tax?
Okay, I think that is a slightly different point. I may have misunderstood your...
That's what I was trying to say. I'm saying that he could have gone to the FTT, he absolutely could have. And if he did, he would have walked into the Section 50 jurisdiction. He didn't, he went to the JR. He nevertheless should have paid the tax. Does that help my the court?
Yes,
And the tail piece is that having gone down the route of the JR, paying the tax wouldn't have rendered the JR nugatory. Either because he could have got a declaration, or he could have paid 14 million and not the interest. So I hope that's clear, and I'm sorry if it wasn't, but that's all I want to say. He could have gone to the FTT, he didn't, he went to the JR, should have paid the tax anyway. And having an arguable JR case isn't a good reason to not pay the tax. And you've got the point about the absence of evidence about whether that was the reason or whether it was causative. That's true either of the GR claim of itself or the worry about it being rendered nugatory, or this risk, which I don't accept was a risk, and certainly can't be found to be a risk, and with the findings of fact that we do and don't have about the risk of paying the revenue and not getting your money back. Then on to reasonable expectation. Well, taking these, the closure notice, I think the way it's put is that this was a gross and obvious error. Well, with my respectful submission, it wasn't. It was cured by Section 114. In a world in which Mr. Archer knew what the tax charge was, etc., etc.
Yeah. So you can't just look at the assessment on its own. You've got to look at
Everything.
the whole.
No question of being misled. No question. All that. Because the question here is, did he know what the amendment to his self-assessment was? That's why when the Court of Appeal said it's really a form, not of substance, what they were saying is you knew perfectly well. Again, we've got this. It's the same old point. We need evidence as to Mr. Archer saying this was the reason I didn't pay, and that's what caused me not paying. Also, this cuts across Section 118 little 2. The Court's familiar with 118 little 2. That's a statement, not a question. This is where the revenue if the revenue agrees.
To delay.
So we've got that in the tax code. If the revenue agrees to give you time to pay, then you can't be hit with the surcharge for not paying. It cuts across that statutory scheme to say, well, if you don't like the closure notice because you don't think it's cured by 114, you don't have to pay. interim relief. Well, again, there was no interim relief from 21st February to 7th March, and then from 30th November onwards, the revenue agreed not to enforce the debt. But the very application for interim relief presupposes a debt. It says the revenue can't enforce it. I'll show the court the orders. But again, no evidence that this is what was Mr. Archer's mind, and this is what caused him to not pay the tax. The revenue couldn't enforce it, that's true. And the self-assessment statements that the court saw these, or at least what the tribunals said about them, collection suspended. In my respect for submission, you can't really say much about that except they mean what they say. We are suspending collection. And the way we put it in the skeleton is that there are many, many, many circumstances in which the revenue think, well, this taxpayer is not going to pay. That doesn't mean the taxpayer's got a reasonable excuse for not paying. Now, the cross-check, a hypothetical appeal would have resulted in a postponement. I simply adopt what the Upper Tribunal, I agree with what the Upper Tribunal said, that actually you can't postpone this tax in this case, but in any event it's not relevant. The question is, in the circumstances of Mr. Archer, was it reasonable of him not to pay his tax? And then the final submission, with the court's permission, on the particular reasonable excuses, unreasonable delay. What I say about this is it depends which of these excuses you look at. Arguable JR claim of itself, or payment would have rendered it nugatory, or reasonable expectation by reference to closure notice, interim relief, or these statements. The JR, the arguability of the JR ceased as from 30th November 2017. Court of Appeal said no, your JR fails. It is these closure notices are cured by the Section 114. After that, what Mr. Archer was doing was exercising rights of appeal. So that's a different reasonable excuse. And again, as a matter of principle, exercising rights of appeal in a different forum, even if you could establish as a matter of evidence that's the reason that was in your head which caused you not to pay the tax, is not reasonable because it cuts across the statutory provisions that say if you don't appeal, you pay the tax. If you don't appeal, you pay. Section 59B5. If you do appeal, you pay subject to postponement at the absent APN. And if you haven't paid, there is a surcharge. One if you haven't paid within these 28 days, the other after 6 months. So in a pay now, argue later world, the reasonable taxpayer pays their tax and says, well, if I win, I get my money back.
Could the, I don't want to, trying to avoid getting into that knotty problem of whether postponement would have been possible in this case. Would there have been any time limit on the revenue completing the representations?
No.
There's a time limit for making an application for making representations, but the revenue can take as long as they like to respond.
That's right.
So all that's going through my head is that if you were to consider this hypothetical appeal to the FTT and then the issue arose as to whether postponement was possible and this argument was raised, HMRC could have completed the representation process.
Oh, absolutely, in
to,
your own hands.
and therefore,
Crystallise
and
it.
then there wouldn't have been any question of the tax being capable of being postponed.
Exactly right. Exactly right. As well as the Section 50 jurisdiction. Exactly, my lady.
Mm.
And that's the regime that Parliament has enacted. I wonder if now is a...
I think it probably is. Not holding you to it, but just to give us an idea, how long do you think you'll be tomorrow morning?
Perhaps an hour and a half. I'll try and be quicker.
Well, no, I'm not inviting you to hurry or anything. I just wanted to have an idea whether we're on track. But it sounds as though we are on track, and there'll be time for Miss Brown to respond.
So,
Very good. Thank you. 10:30 tomorrow then.